Usually when we think about a building, the foundation is like the most important part.
Right, absolutely.
You lay down this solid slab of concrete, and you just sort of assume the house built on top of it is going to look basically the same no matter where you are in the world.
Yeah. Four walls, a roof, a door.
Exactly.
That is the universal expectation of architecture. I mean, the physics of keeping the rain out don't really change based on your zip code.
But then you step into the world of global justice and international law.
Oh, and the architecture completely shifts.
Totally. Because we have the United Nations, right?
Yeah.
Which gave us the Universal Declaration of Human Rights, the UDHR, back in 1948.
The ultimate foundation.
Right. That was supposed to be the universal foundation for human dignity, a common standard of achievement for all peoples.
Yeah.
When you look at the actual structures built on top of that foundation around the world,
They don't look like the same house at all.
not even close.
And that's because the environment dictates the architecture. While the UN provides that incredible foundational baseline, saying, here are the basic requirements to shelter a human life.
The reality of building it is different.
Exactly. The reality of constructing that shelter changes drastically depending on the local weather. And I mean historical weather.
Like state violence or oppression.
Yes. Systemic inequality. These are regional hurricanes and earthquakes, and they require highly specific, localized engineering to withstand.
Which brings us perfectly to today's topic. Welcome to your deep dive.
Glad to be here.
So, to you listening, you handed us a massive stack of source material today. You specifically requested we act as your personal study guide for a pretty monumental academic challenge.
It's a fantastic challenge.
We are opening up the Osmania University Law syllabus, and we are unpacking Unit 3, Regional Conventions on Human Rights.
Which is such a fascinating exercise because this specific unit, it forces a student to look past the soaring idealism of global declarations, right?
Yeah.
And examine the actual grinding machinery of justice. We're taking the theories of human rights and putting them right in the courtroom.
And we have a dense stack to get through. Legal texts, parliamentary handbooks, international treaties.
Yeah.
Our goal is to break these massive continent-spanning frameworks down.
So you can walk into your exam or your next debate with absolute clarity.
Okay, so let's unpack this. We have the UN, we have the International Bill of Human Rights.
The Universal Declaration, the Covenant on Civil and Political Rights.
Right, and the Covenant on Economic, Social, and Cultural Rights. So if we have all these universal rules agreed upon by the world at the UN level, the most obvious question looking at this Osmania syllabus is, why do we even need regional human rights systems?
It almost sounds like a contradiction.
Right. The phrase regional human rights sounds like an oxymoron. If right is human, shouldn't the enforcement be global?
Well, the theory definitely suggests global enforcement, but the reality of international law runs directly into the brick wall of state sovereignty.
The ultimate roadblock.
Exactly. The UN is this sprawling apparatus of nearly 200 countries. Just getting that many distinct cultures and geopolitical rivals to agree on a philosophical baseline is a miracle in itself.
Let alone enforcing it.
Exactly. Getting them to agree to surrender their sovereign power to a global court that can legally punish them. That is a bridge way too far for the current international order.
Yeah, I was reading through the introductory notes in the syllabus, and it seems the fatal flaw of the UN system is that it relies almost entirely on, well, naming and shaming.
Naming and shaming, exactly.
Like, there are committees, there are reports, but if a sovereign nation decides to just ignore a UN resolution condemning its actions...
There isn't an international police force coming to arrest the head of state.
Right, it's like a strongly worded letter.
And that is the crux of the issue. Regional systems step into that exact enforcement void. Countries within a specific geographic region, like Europe, the Americas, or Africa, they often share much closer historical ties.
Trade routes, political philosophies.
Yes. And critically, they often share the scars of the same historical traumas. Because of that proximity, they are way more willing to surrender a portion of their sovereign power to a regional body than to a distant global one.
They trust their neighbors slightly more than they trust the entire globe.
That captures the dynamic beautifully. And examining your Unit 3 syllabus, we are going to study the three most prominent builders in the world.
The European system, the Inter-American system, and the African system.
Right. Each one has evolved entirely distinct legal mechanics to protect the individual. And those mechanics were born out of their unique, localized nightmares.
Okay, let's start where the syllabus starts. Europe. The source material refers to it as the most developed machinery for human rights enforcement on the planet.
The gold standard.
To understand why Europe went so aggressively into hard legal enforcement, I looked at the timeline. The foundational organization here is the Council of Europe, founded in 1949.
That date tells the entire story.
Right after World War II.
Exactly. 1949 places us squarely in the smoldering ashes of the Second World War. The atrocities of the Holocaust, the systemic dismantling of democracy, the rise of fascism.
It was a horrifying, undeniable lesson.
The lesson was that a sovereign state cannot be trusted to protect its own citizens. I mean, prior to WWII, international law largely dictated how states treated other states.
Like treaty disputes and trade.
Right. What a state did to its own people within its own borders, that was its own business.
Which is terrifying, because the Nuremberg laws in Germany were, technically speaking, domestic laws passed by a sovereign government.
Precisely. Domestic law failed to protect humanity. So the architects of the European system realized that the fundamental rights of the individual had to be formally protected against the tyranny of their own government.
By a supranational authority.
Yes. The Council of Europe was created specifically to promote democracy, the rule of law, and human rights.
Let me pause here real quick, because this is a massive trap for students studying this material. The Council of Europe is not the European Union.
Oh, a vital distinction for your exam. Do not confuse them.
Right.
The European Union is a politico-economic union, primarily focused on a single market, trade, integration.
Passports, currencies, things like that.
Exactly. The Council of Europe is a completely separate, older international organization. It currently has 47 member states, covering almost the entire European continent, over 800 million citizens.
Wow. Okay, so the anchor document for this massive organization is the European Convention on Human Rights, or the ECHR, adopted in 1950, entered into force in 1953.
Yes.
Going through the text of the ECHR in our sources, it reads very much like a classic post-Enlightenment civil liberties document.
It really does.
It focuses intensely on civil and political rights. The right to life, freedom from torture, right to a fair trial, freedom of expression, assembly.
And that was intentional. The drafters prioritized rights that could be clearly defined and legally enforced in a courtroom setting. They wanted rights that were justiciable.
Which makes sense. But a list of rights is merely poetry without a mechanism to enforce them, right?
Beautiful poetry, but legally useless. The defining feature of the European system, the machinery that makes it the gold standard, is the European Court of Human Rights.
The ECTHR, based in Strasbourg, France.
Yes.
I spent a lot of time reviewing how a person actually gets a case into this court.
Yeah.
And the evolution of the Strasbourg machinery is fascinating, because according to the syllabus, the system didn't start out with direct access for individuals.
No, the original design was quite cautious. If you were a citizen whose rights were violated, you couldn't simply sue your government in the Strasbourg court.
So what did you do?
You had to file a petition with the European Commission of Human Rights. There was a two-step process.
Okay.
The commission acted as a gatekeeper. They would investigate the facts, try to arrange a confidential, friendly settlement between you and your government.
And if that failed?
Only if that failed would the commission or the state involved decide if the case should be forwarded to the actual court for a binding legal judgment.
Okay, but the sources emphasize a major paradigm shift called Protocol 11. But actually, let me make sure we define our terms clearly for the listener. When the syllabus mentions a protocol to a treaty, what exactly is that?
That's a great question. Think of a protocol as a legal amendment or an addendum to the original treaty.
Like a software patch.
Exactly like a software patch. As international treaties age, the drafters realize they need to update the machinery, add new rights, or fix procedural bottlenecks instead of throwing out the entire original treaty and starting over.
Which would be impossible to get everyone to agree to again.
Exactly. They draft and ratify a protocol. It attaches to the anchor document and legally modifies it for the states that agree to it.
Got it. So Protocol 11, which came into force in 1998, completely rewired the House. It abolished the commission entirely.
Yes, the two-tier system was scrapped in favor of a single, permanent, full-time court.
And the most revolutionary aspect of this update is that it allowed individuals to petition the court directly.
And the historical significance of that shift really cannot be overstated. Think about it. For an ordinary citizen, a single individual without the backing of an army or a vast fortune, to possess the legal standing to drag their own sovereign government before an international tribunal of judges from 47 different countries.
It's wild when you put it like that.
It upends centuries of Westphalian state sovereignty. It is the ultimate realization of making human rights practically enforceable. Any person, NGO, or group claiming to be the victim of a violation by a state party can submit an application directly to the ECTHR.
But wait, I was reading through the admissibility criteria because my immediate thought was, this is going to be chaos.
Oh, is a concern.
Right. You have 800 million citizens.
Yeah.
So if I get a parking ticket in Paris, feel the local police were rude to me, and believe my right to a fair trial was violated by the local traffic magistrate, I can't just immediately fire off an email to the judges in Strasbourg, right?
No, no.
The system would collapse in an afternoon.
And the designers of the system anticipated that exact chaos. The European Court is not a court of first instance. It is an international safety net, not a replacement for domestic justice.
Okay, so what's the filter?
The most critical admissibility criterion, and a concept you will see applied across almost all international law, is the exhaustion of domestic remedies.
Yes, I read about this. I think the best way to conceptualize the exhaustion of domestic remedies is to look at how we handle local disputes here.
How do you mean?
Well, if you live in a neighborhood with a homeowners association, an HOA, and your neighbor builds a fence that violates the property line, you don't instantly file a lawsuit in your country Supreme Court.
Right, they'd laugh you out of the room.
Exactly. You have to take the grievance to the local HOA board. If they rule against you, you appeal to the city zoning commission. If they rule against you, you go to the municipal court, then the state appellate court, and so on.
That's a perfect analogy.
You must use every single localized tool available before a higher authority will even acknowledge your paperwork.
And that analogy perfectly illustrates the principle of subsidiarity. Subsidiarity dictates that the national authorities, the domestic courts of the member states, have the primary responsibility to secure the rights laid out in the Convention.
They get the first crack at fixing the problem.
Exactly. The European system operates on the assumption that domestic judges are perfectly capable of reading the ECHR and applying it. Therefore, an applicant must have taken their case all the way up the judicial ladder to the highest possible appellate court in their own country before knocking on the door in Strasbourg.
Okay, that filters a lot out. And the syllabus notes there are strict temporal filters as well.
Yes, time limits. The clock starts ticking the moment that final domestic decision is handed down. If the Supreme Court of your country rejects your final appeal, you have a strict 6-month window to file your application with the ECTHR.
Oh, wow. 6 months goes fast.
It does. Furthermore, the application cannot be anonymous. The court needs to verify that the applicant is the actual victim. And crucially, the act complained of must be attributed to a public authority of the state.
So I can't sue a private corporation in Strasbourg.
No, or your neighbor. You are suing the state for its failure to protect your rights or its active violation of them.
But even with all that, the exhaustion of domestic remedies, the 6-month window, the victim requirement, the volume of cases pouring into Strasbourg is staggering.
It really is overwhelming.
According to the data in our source stack, the court receives tens of thousands of applications every single year. The backlog at one point reached well over 100,000 pending cases.
Which is a crisis.
Right. A justice system with a 100,000 case backlog is functionally paralyzed. A human right delayed by a decade of paperwork is basically a human right denied.
The court became a victim of its own success. When 800 million people have a direct line to a single international court, administrative gridlock is inevitable.
So how did they fix it?
Well, this massive caseload necessitated further structural remodeling through additional protocols. Protocol 14 was introduced specifically to optimize the filtering and processing of this mountainous backlog.
Okay, so how does Protocol 14 actually clear the pipes? The syllabus mentions it allows simpler cases to be heard by smaller judicial formations.
Right. Prior to these reforms, an admissibility decision or a judgment on the merits often required a chamber of 7 judges to deliberate, which takes time.
Too much time for 100,000 cases.
Exactly. So Protocol 14 allowed a single judge to outright reject clearly inadmissible applications.
Like if they missed the 6-month deadline.
Yes, or clearly hadn't exhausted domestic remedies. For cases that are repetitive, where the court has already established clear, well-known case law regarding a specific issue in a specific country, a committee of just 3 judges can rule on it.
That makes sense. Reserve the heavy lifting for the new stuff.
Precisely. Reserving the full chambers and the grand chamber for novel, complex legal questions preserves the court's resources.
The sources also detail the introduction of Protocols 15 and 16 as more recent structural fixes. And looking at Protocol 16, it introduces a fascinating mechanism regarding advisory opinions.
Oh, Protocol 16 is a brilliant procedural innovation.
Okay, explain that one.
It allows the highest domestic appellate tribunals of member states to request advisory opinions from the European Court on questions of principle relating to the interpretation or application of the rights in the Convention.
Okay, let me make sure I understand the mechanics of this. Say a domestic Supreme Court is hearing a case, let's say, about mass surveillance and digital privacy.
A very common modern issue.
Right. They're looking at the ECHR, but the technology is brand new, and they aren't sure how the Strasbourg judges would interpret the right to privacy in this specific digital context.
Okay.
Before the domestic court issues a final ruling, which might be wrong and trigger a massive years-long lawsuit in Strasbourg later, they could essentially hit pause, send a memo to Strasbourg, and ask, how do you interpret this specific principle?
That is the exact mechanism. It is a preemptive dialogue. By providing domestic courts with guidance before they issue their final judgments, Protocol 16 prevents human rights violations before they even happen.
Wow, that's smart.
It empowers national judges to apply the convention correctly the first time, which ultimately keeps those cases out of the Strasbourg backlog. It reinforces the principle of subsidiarity by making the domestic courts active partners.
Rather than just waiting to be overturned on appeal 10 years later.
Exactly.
Now, we've focused heavily on the ECHR, and examining the text, it's clear this document is primarily concerned with what we call first-generation rights.
Civil and political liberties.
Right. Freedom of speech, fair trials, protection from torture. These are negative rights. They require the state to step back and not interfere with the individual.
But reading further into the syllabus, there is a second major pillar to the European architecture. Does Europe just ignore economic, social, and cultural rights?
Not at all. The Council of Europe recognized that political freedom is essentially incomplete without economic security. To address economic, social, and cultural rights, often termed ESCR, they created a separate complementary treaty.
The European Social Charter, originally adopted in 1961 and extensively revised in 1996. The separation of these rights into two distinct treaties is a crucial structural choice you must understand for this syllabus.
And the enforcement mechanism for the Social Charter is completely different from the ECHR. Like, you don't have individuals suing their governments in a courtroom over a lack of housing.
No, you don't.
The sources explain the Social Charter is divided into two distinct parts, and this division is, honestly, a masterclass in how international law attempts to manage economic reality.
Because the drafters understood that you cannot mandate economic prosperity by judicial decree. If a country is impoverished, a judge ordering the government to provide world-class free healthcare to every citizen tomorrow is legally meaningless.
The money simply doesn't exist.
Exactly. Therefore, Part 1 of the Social Charter contains aspirational rights.
The source text describes these as broad policy aims that states undertake to fulfill subject to the principle of progressive realization.
Progressive realization is the acknowledgement that fulfilling economic rights takes time and resources. Part 1 is a declaration of political intent. It contains statements such as, all workers have the right to just conditions of work, or anyone without adequate resources has the right to social and medical assistance.
I look at Part 1 as the international equivalent of a public New Year's resolution.
A New Year's resolution.
Yeah. A government signs it and publicly declares, we are going to improve our infrastructure, we are going to expand healthcare, we are going to work toward zero unemployment.
Yeah.
It is a genuine goal, and they are committing to moving in that direction.
I see.
But a citizen cannot file a lawsuit on January 3rd claiming their rights were violated because the government hasn't achieved total economic utopia yet.
That's a great way to put it. The legal enforceability is indeed progressive rather than immediate. However, Part 2 of the Social Charter pivots dramatically.
Okay, what's Part 2?
Part 2 contains specific rights that are immediately binding upon the member states that accept them.
So if Part 1 is the New Year's resolution, Part 2 is the signed mortgage contract. It is a hard, enforceable obligation.
Exactly. These obligations include specific protections like the right to equal pay for equal work, the right to strike, the protection of young persons in employment, and the right to Social Security.
But if there isn't a trial, how does the enforcement work? The syllabus outlines the European Committee of Social Rights as the enforcement body here. How do they force states to comply with their Part 2 mortgage contracts?
Well, because economic rights often involve complex budgetary policies rather than a single act of state violence, the primary mechanism is a rigorous reporting system. States parties must submit detailed annual reports to the committee proving, with data and policy analysis, that they are complying with their binding obligations.
And who reviews these reports?
A committee, composed of independent, impartial experts, reviews them and issues conclusions.
I was wondering about those conclusions. What happens if a state's report clearly shows they are failing to provide adequate Social Security and the committee issues a negative conclusion? Is there a penalty?
The conclusion itself is a formal legal assessment. If a state refuses to bring its policies into compliance after a negative conclusion, the Committee of Ministers, the political arm of the Council of Europe, can adopt a recommendation directly targeting that state, demanding legislative changes.
Okay.
Furthermore, the 1995 Additional Protocol introduced a collective complaint procedure.
The collective complaint procedure. That seems like a fascinating bridge between the individual focus of the ECHR and the broad policy focus of the Social Charter.
It is. Under this procedure, designated organizations such as major trade unions, employers' organizations, and specific international NGOs can file complaints directly against a state for failing to apply the charter properly.
So it is not an individual victim bringing a case, but a collective entity challenging a systemic structural failure.
Right. The committee assesses the complaint and issues a legally binding decision on whether the state has violated the charter.
Wow. Okay, so to pull all of these threads together for your exam preparation regarding the European system, the architecture is defined by heavy institutionalization and strict legal precision.
Very strict.
It relies on a powerful, direct access, single-tier court in Strasbourg to enforce civil and political rights, treating them as binary justiciable laws. Simultaneously, it uses a dedicated committee, progressive realization, and collective complaints to push states toward fulfilling economic and social rights.
It is a system built by nations that watch the rule of law evaporate into tyranny and determined that strict, supranational judicial oversight was the only cure.
A comprehensive synthesis. Yeah. The European model assumes that the primary threat to human rights is legislative tyranny or executive overreach within a relatively functioning legal state.
Which can be corrected by an international appellate court.
Right. But if we cross the Atlantic Ocean to examine the next syllabus topic, we encounter a region that faced a completely different breed of terror in the 20th century. Let's turn the page to the Inter-American system.
Yes, a very different architecture.
Looking at the geopolitical context in the source material, the human rights arrangements in the Americas are nested within the Organization of American States, the OAS.
Which is the oldest regional organization in the world, tracing its roots back to 1889, though the modern OAS charter was signed in 1948.
The OAS encompasses 35 member states across North, Central, and South America, as well as the Caribbean. The anchor document for their specific human rights machinery is the American Convention on Human Rights, universally referred to as the ACHR, or the Pact of San Jose, adopted in 1969, enforced by 1978.
But there's a catch.
Yeah, a big one. I was cross-referencing the list of states that have actually ratified the ACHR against the map of the OAS, and there is a glaring geopolitical reality that we have to address to understand this system's limitations.
Some of the most powerful geopolitical forces in the hemisphere are conspicuously absent.
Exactly. While the ACHR is the definitive regional instrument, major states like the United States and Canada have never ratified the convention.
It is a critical piece of structural context. They are members of the OAS and therefore subject to the broader, older American Declaration of the Rights and Duties of Man, but they are not legally bound by the specific supervisory machinery of the court established by the ACHR.
And it's not just the U.S. and Canada. The system has faced significant pushback from others, too.
Yes. Venezuela, for example, formally denounced the convention and withdrew from the court's jurisdiction in 2012. Trinidad and Tobago denounced it in 1998.
So the map of who is actually submitting to the binding authority of this system is pretty fragmented.
Yeah.
Now, delving into the actual mechanics of the ACHR for the states that are bound by it, the architecture is fundamentally different from Europe.
Oh, completely. Europe evolved into a single direct access court.
But the Inter-American system operates on a strictly maintained dual-track or gatekeeper approach.
Yes. There are two distinct organs. The Inter-American Commission on Human Rights, based in Washington, D.C., and the Inter-American Court of Human Rights, based in San Jose, Costa Rica.
To understand this system, we have to talk about the Commission first, right?
exhaustively analyze the commission first because its role is paramount. The commission is not merely an administrative stepping stone, it is the beating heart of the system.
Okay, so how does it work?
It acts simultaneously as a filter, an investigator, a mediator, and a prosecutor. If an individual in a state party to the ACHR suffers a human rights violation, they do not pack their bags and head to the courtroom in Costa Rica.
They must file a petition with the commission in Washington, D.C.
Exactly.
And I was reading through the rules governing who can file a petition with the commission, and I found the most crucial, defining difference between the Americas and Europe.
Ah, yes. The standing requirement.
Right. We spent all that time establishing that in Europe, the Strasbourg court demands strict victim status. The person filing the paperwork must be the person who suffered the harm. But in the inter-American system, you do not have to be the victim to file a petition.
This is perhaps the most vital legal adaptation to regional historical realities we will discuss in this entire syllabus.
That's a huge deal.
Article 44 of the American Convention establishes a system of actio popularis. Any person, group of persons, or legally recognized non-governmental entity can lodge a complaint with the Commission denouncing a violation of the Convention by a state party.
So the petitioner does not need to be the victim.
Nor do they need to have the direct authorization of the victim.
I had to stop and ask myself why a system would open the floodgates like that. Why allow a human rights NGO in New York to file a petition on behalf of a citizen in Argentina who they've never even met?
And the answer lies in the specific nightmares the Americas faced in the 1970s and 80s.
We aren't talking about bureaucratic overreach or unfair zoning laws here.
No. We are talking about the era of military juntas, Operation Condor, and the horrifying phenomenon of forced disappearances.
Let's explain what that actually means, because it's chilling.
A forced disappearance is not a standard arrest. It is when state security forces, often in civilian clothing or unmarked vehicles, abduct a person.
Just snatch them off the street.
And then the state actively denies having the person in custody, refusing to acknowledge their whereabouts or their fate. The victim is placed completely outside the protection of the law. They vanish into secret detention centers.
So if the rule for filing a human rights complaint is that only the victim can file the paperwork, and the victim is blindfolded in the basement of a secret military facility.
The legal system is utterly useless.
Exactly. The state can commit atrocities with absolute impunity because they have physically incapacitated the only person with legal standing to complain.
Precisely. By designing a system that allows third parties, mothers, spouses, human rights organizations, or concerned citizens to file petitions on behalf of the disappeared, the inter-American system adapted its machinery to fight clandestine state violence.
It ensured that even if a victim was silenced, the alarm bells could still be rung in Washington, D.C.
Yes.
Okay, so the commission receives the petition. Then what? How do they process a claim that a shadow government is disappearing people?
The commission investigates. They request information from the state. They often conduct on-site visits to the countries in question.
Yeah, they actually go there.
Yes. Interviewing witnesses, visiting prisons, gathering evidence on the ground, which is a power the European Court does not possess in the same investigative manner.
Wow.
The commission attempts to facilitate a friendly settlement between the victim's representatives and the state. If the state refuses to settle or refuses to acknowledge the violation, the commission issues a formal report outlining its conclusions and making specific recommendations to the state to remedy the situation.
And if the state simply ignores the commission's report?
Only then, if the state fails to comply with the recommendations, does the commission have the authority to refer the case to the Inter-American Court of Human Rights in Costa Rica.
So the individual citizen never actually knocks on the door of the court themselves?
No. The commission acts as the prosecutor, bringing the case against the state before the judges in Costa Rica.
I noticed another massive hurdle in the syllabus regarding the court. The source material uses the phrase contentious jurisdiction. Even if a state has ratified the American Convention, that doesn't mean the court can issue binding judgments against them automatically. What exactly is contentious jurisdiction?
Think of it as signing a binding arbitration clause in a commercial contract. Ratifying the ACHR means a state agrees to the rules of the treaty and the authority of the commission. But to be tried before the court, a state must make a separate, explicit declaration accepting the court's contentious jurisdiction. It is an optional clause.
So if a state hasn't accepted that specific jurisdiction,
The commission cannot send the case to the court. The commission's report remains the final word.
Man, that's an incredible amount of gatekeeping. But when the gates do open and a case actually reaches the judges in San Jose, the jurisprudence that comes out of that court is profoundly impactful.
Extremely impactful.
The syllabus specifically highlights a landmark case that illustrates exactly how this court dismantles clandestine state violence. Velázquez-Rodriguez v. Honduras.
Velázquez-Rodriguez. It is arguably the most important foundational case in the inter-American system's history. Decided in 1988.
It provided the definitive legal blueprint for how international tribunals address forced disappearances.
Exactly.
I was reading the brief on this case. Manfredo Velázquez-Rodriguez was a university student in Honduras. In 1981, he was violently abducted in broad daylight by heavily armed men in civilian clothes. Witnesses noted the vehicles lacked license plates but were commonly associated with Honduran state security forces. He disappeared completely.
And the state's response?
The police and the courts in Honduras denied any knowledge of his arrest or detention. The family exhausted domestic writs of habeas corpus to no avail, and eventually the case was brought to the commission and then to the court.
The evidentiary hurdle facing the court was monumental. Think about it. The entire purpose of a forced disappearance is to leave no paper trail.
Right. There are no arrest warrants, no prison logs, no bodies.
So how does an international court prove, beyond a reasonable doubt, that a sovereign state is legally responsible for a kidnapping when the state categorically denies involvement and there is no direct documentary evidence linking the abductors to the government?
Yeah, how did the court pierce that veil? If Honduras simply says, it wasn't us, it must have been a random criminal gang, how does the court definitively pin the blame on the government?
The court made a groundbreaking ruling on the nature of evidence and state responsibility. They acknowledged that requiring direct, documentary proof of clandestine operations would render the human rights system completely impotent.
You can't ask for a receipt from a secret police force.
Exactly. Therefore, the court relied heavily on circumstantial evidence, logical inferences, and presumptions based on the broader geopolitical context.
They looked at the pattern.
Yes. The commission presented extensive evidence demonstrating a systematic, state-sponsored practice of disappearances occurring in Honduras at that time, targeting individuals considered subversive by the military.
And Velázquez-Rodriguez fit that profile.
Precisely. The court ruled that if it could be proven that a systematic practice of disappearances existed, and if Manfredo's abduction fit the specific profile of that practice, the burden of proof shifted to the state.
Oh.
The state had to prove it didn't do it.
And Honduras couldn't prove a negative, especially when the domestic courts had actively refused to investigate the disappearance when the family initially filed the writs of habeas corpus.
The court's final judgment was monumental. They ruled that forced disappearance is a multiple and continuous violation of numerous rights simultaneously.
The right to personal liberty, the right to humane treatment.
Because prolonged incommunicado detention inherently constitutes cruel and inhuman treatment. And the right to life. Even though nobody was found, the context of the systematic practice allowed the court to presume Manfredo had been arbitrarily deprived of his life.
Velázquez-Rodriguez established the principle that a state cannot hide behind the shadows of ununiformed agents. It holds the entire state apparatus accountable.
It was a massive victory for human rights.
So, moving beyond the trial phase, there is another tool in the inter-American system that the syllabus highlights, and it completely reframes how an international court can operate. I'm referring to provisional measures.
Article 63, Section 2 of the Convention. It is one of the most dynamic and frequently utilized mechanisms in the Americas.
The text says that in cases of extreme gravity and urgency, and when necessary to avoid irreparable damage to persons, the court can adopt provisional measures. I conceptualize this as a legal emergency room.
The legal emergency room is an apt description. The traditional international court process, filing a petition, gathering evidence, the commission writing a report, transferring it to the court, arguing the merits, that can take years, sometimes over a decade.
But what happens if the human rights violation is imminent?
Right. What if a journalist is receiving credible death threats from a paramilitary group today? What if an indigenous community is facing violent forced eviction from their ancestral lands tomorrow morning?
If they have to wait 10 years for a judgment from San Jose, the journalists will be dead and the community will be destroyed. A posthumous check for damages doesn't protect the right to life.
Exactly. In those scenarios of extreme gravity, urgency, and potential irreparable harm, the commission can request and the court can order binding provisional measures immediately.
So they just issue an injunction.
Yes. The court can issue an emergency injunction ordering the state to take immediate tangible action. They can order the state to provide an armored vehicle and 24-hour armed bodyguards for a threatened human rights defender.
That is wild.
They can order the state to immediately halt the construction of a dam that threatens an indigenous water supply until the full legal case is heard.
That shifts the paradigm entirely. It moves the court from being a mechanism that merely dispenses compensation after a tragedy to an active participant intervening on the ground to keep people alive while the gears of justice slowly turn.
To be fair, the European Court possesses a similar mechanism known as interim measures under Rule 39 of the Rules of Court, often used to halt deportations.
Sure.
But in the inter-American system, given the historical context of imminent physical threats to life from both state and non-state actors, provisional measures have literally saved hundreds, perhaps thousands, of lives. It is a defining feature of the architecture.
To synthesize the inter-American system for your exam, it is a dual-track architecture designed to combat shadows. It relies on a powerful investigative commission acting as a gatekeeper, uniquely adapted with the actio popularis mechanism to allow third parties to fight clandestine state violence when victims cannot speak for themselves.
And the court, while harder to access due to the requirement of contentious jurisdiction, issues deeply structural judgments on state accountability.
Utilizing circumstantial evidence to prove systematic abuses and wielding powerful provisional measures to act as an emergency brake on imminent harm.
A thorough summary of the Americas.
So we have seen Europe's direct access appellate model. We've seen America's investigative gatekeeping model. Now, our syllabus requires us to cross the Atlantic once more, where we encounter a system that does not merely alter the procedural machinery, but fundamentally redefines the philosophical nature of the rights themselves.
Yes, the African system.
We are opening the files on the African system. Looking at the foundational timeline, the human rights architecture in Africa is rooted in the Organization of African Unity, the OAU, which was established in 1963. The OAU has since evolved into the modern African Union, the AU.
The date of 1963 provides the necessary historical lens. Unlike Europe, which was rebuilding from the ashes of a global war between industrialized powers, the African continent in the mid-20th century was engaged in a monumental struggle against external subjugation.
Colonization.
Yes. The primary objectives of the OAU at its inception were to rid the continent of colonization, secure sovereign independence for African nations, and dismantle the horrors of apartheid in South Africa.
And that anti-colonial DNA is woven directly into their anchor document,
Wow.
the African Charter on Human and People's Rights, universally known as the Banjul Charter, adopted in 1981, effective in 1986.
And examining the text of the Banjul Charter side by side with the European and American conventions, it's staggering. It reads completely differently.
The Banjul Charter is uniquely and proudly African. The drafters consciously chose not to simply copy and paste the European or UN templates.
They sought to blend international human rights standards with the specific needs, historical experiences, and philosophical values of African civilization.
The first major structural difference I noted in the source material is its holistic approach. We discussed how Europe physically separated civil and political rights into the ECHR and economic and social rights into the Social Charter, enforcing them with entirely different mechanisms.
The Banjul Charter shatters that division.
Right. It puts civil, political, economic, social, and cultural rights into one single binding document.
This reflects a profound philosophical stance on the indivisibility of rights. From the perspective of nations struggling with extreme poverty and the legacy of colonial resource extraction, dividing rights into categories is an artificial Western luxury.
Right, like saying you can vote, but you can't eat.
Exactly. The African perspective argues that the right to vote in a democratic election or speak freely in the town square is functionally meaningless if you are starving to death, lack access to clean water, or are dying of preventable diseases. Economic survival and political freedom are inextricably linked.
You cannot separate the right to life from the right to the resources necessary to sustain that life.
Precisely. But the most radical departure in the Banjul Charter is right there in the title, the African Charter on Human and People's Rights.
The syllabus highlights the introduction of what scholars call third-generation rights.
Earlier human rights treaties, the first generation of civil rights and the second generation of economic rights, focus almost exclusively on the individual. The Banjul Charter expands the scope to confer legally recognized rights upon peoples as a collective, cohesive group.
The text lists specific collective rights: the right to self-determination, the right to economic, social, and cultural development, the right to national and international peace, and critically, the right of peoples to the free disposal of their wealth and natural resources.
You can clearly trace the shadow of colonialism in those provisions. Western powers had spent centuries extracting wealth, minerals, and human labor from the continent without the consent of the people.
So by enshrining the right of peoples to control their own natural resources, the Banjul Charter elevates anti-colonial principles to the level of fundamental, enforceable human rights.
It asserts that a community or a nation has a sovereign right to its own economic destiny.
That makes historical sense. But there is another section of the Banjul Charter that completely upends traditional Western legal philosophy. As I was going through the source stack, I hit Chapter 2, and it genuinely forced me to reread the text several times.
I know what you're talking about.
The Banjul Charter includes a detailed section on duties. Article 29 lists specific individual duties to the family, to the society, to the state, and to the international African community.
Yes. The inclusion of duties is perhaps the most debated and philosophically distinct aspect of the African system.
I mean, I am struggling to reconcile this. From the Magna Carta to the UDHR, the entire historical point of a human rights document is to act as a shield. It is designed to protect the small, vulnerable individual from the massive coercive power of the state.
Right.
So why would a human rights charter hand the state a legal weapon to demand duties from the individual? Doesn't that contradict the very premise of human rights?
That tension is exactly why it is a brilliant syllabus topic. The inclusion of duties represents a profound philosophical divergence from Western individualism. In Western liberal philosophy, the individual is often viewed as an autonomous, self-contained unit.
Right.
The individual exists almost in opposition to the state or society. Rights are barriers erected to keep society out. Leave me alone, I have rights.
The classic "my home is my castle" mentality.
However, in many African philosophical traditions and customary laws, often encapsulated in concepts like Ubuntu, the individual does not exist in a vacuum. The individual is inherently embedded within a community. Your identity, your survival, and your very humanity are defined by your relationships and interactions with your family, your village, and your society.
I am because we are.
Precisely. The drafters of the Banjul Charter argued that you cannot simply extract the individual, grant them a list of unassailable rights, and ignore the community that sustains them. You cannot enjoy rights without simultaneously acknowledging your obligations to preserve and nurture the community that guarantees those rights in the first place.
So it's a symbiotic legal framework. You have a right to be supported and protected by your family unit. But Article 29 explicitly states you also have a duty to respect your parents and care for them in their old age. You have a right to liberty and security, but you have a corresponding duty not to compromise the security of the state and to pay taxes imposed by law in the interest of the society.
It is an ambitious attempt to balance individual freedom with deep social cohesion. However, your initial concern regarding state power is highly valid and extensively debated in international law circles.
Because authoritarians could use it.
Authoritarian regimes could potentially, and have historically attempted to, exploit the concept of duties to the state to crush political opposition or justify oppressive laws under the guise of maintaining social harmony. Which brings us to another unique and initially highly controversial feature of the Banjul Charter, the clawback clauses.
Yeah, I read the section on clawback clauses, and they seem like a massive loophole. To understand a clawback clause, we first have to understand what the Charter's missing. The sources point out that unlike the International Covenant on Civil and Political Rights or the European Convention, the African Charter does not contain a general derogation clause.
Let us define that mechanism for our listener preparing for the exam. A derogation clause is essentially an emergency pause button.
Okay.
It is a provision that allows a state to temporarily suspend certain non-derogable human rights during a time of massive public emergency that threatens the life of the nation, such as a full-scale war.
Like martial law.
Exactly. Europe and the Americas have strict procedural rules for how, when, and for how long a state can push that pause button. The African Charter does not have a general emergency derogation clause.
Instead of an emergency pause button, it has these clawback clauses baked directly into the definition of the individual rights. For example, looking at the text of Article 9, it says, "Every individual shall have the right to express and disseminate his opinions within the law." Article 10 guarantees the right to free association, provided the individual abides by the law.
Therein lies the structural danger. If your fundamental right to free speech or free assembly is only guaranteed within the law, What happens if a corrupt domestic regime simply passes a law making it illegal to criticize the president or form a rival political party?
A dictator can stand before the international community and say, I am perfectly complying with the African Charter. The Charter says free speech is subject to the law. My domestic parliament just passed a law banning all newspapers from mentioning my name. I am enforcing the law, therefore I am upholding the Charter. It seems like a structural flaw that renders the rights completely hollow.
Upon the Charter's adoption, many international legal experts voiced exactly that fear. They believe the clawback clauses rendered the document useless, subordinating international human rights to arbitrary domestic legislation.
So did it.
But the African human rights machinery evolved to close that loophole through brilliant judicial interpretation. The primary monitoring body of the Charter is the African Commission on Human and People's Rights, based in Banjul, the Gambia.
The syllabus specifically highlights a case that demonstrates how the Commission fixed this loophole. Media Rights Agenda v. Nigeria.
It is a critical case study. During the 1990s, Nigeria was ruled by the military dictatorship of General Sani Abacha. The regime systematically clamped down on the press, passing decrees that allowed the government to arbitrarily ban publications, arrest journalists without warrant, and try civilians in secret military tribunals, completely bypassing the regular civilian courts.
And when human rights organizations brought cases against Nigeria before the African Commission, the military regime relied directly on those clawback clauses. They argue that their actions were perfectly legal because they had passed domestic decrees making the press restrictions the law. They were operating within the law.
The African Commission faced a defining moment. If they accepted Nigeria's argument, the Charter was effectively dead.
So what did they do?
The Commission made a masterful interpretive maneuver. They ruled that the phrase within the law in the Banjul Charter cannot possibly mean any arbitrary, oppressive domestic decree a dictator dreams up.
How did they redefine it?
The Commission stated that the law referenced in the clawback clauses must be interpreted to mean international law and international human rights standards. They ruled that a state cannot use its own oppressive domestic legislation to bypass its obligations under the African Charter.
Oh, that's clever.
International human rights standards must always prevail over contradictory national law. A domestic law restricting a fundamental right must be strictly proportionate, necessary, and aligned with international norms, not merely the whim of a military junta.
That ruling effectively defanged the clawback clauses. It established that domestic law is subject to international review, saving the integrity of the Charter. Now, structurally, Africa also established a court, correct? We talked about the Commission in Banjul, but the syllabus mentions the African Court.
Yes, the African Court on Human and People's Rights. It was established by a separate protocol adopted in 1998, which came into force in 2004. The court is seated in Arusha, Tanzania. It was designed to complement and reinforce the mandate of the Commission, adding the weight of binding judicial decisions to the system.
But reviewing the access rules for the African Court, the structural hurdles seem even higher and more restrictive than in the inter-American system. Individuals and NGOs do not have automatic, direct access to the court in Arusha.
The access mechanisms are highly complex and represent a significant bottleneck. The Commission itself, state parties, and African intergovernmental organizations can bring cases directly to the court. But for an individual citizen or a non-governmental organization to bypass the Commission and directly petition the court, a very specific legal threshold must be met.
This involves Article 74.6 of the protocol establishing the court.
Yes. Under Article 34.6, a state party must make a specific, explicit declaration accepting the competence of the court to receive cases directly from individuals and NGOs. If the state has not signed that specific declaration, the court categorically lacks jurisdiction to hear the case, and the individual must go through the Commission.
Given the historical reluctance of states to surrender sovereignty, I'm assuming states aren't exactly rushing to sign a declaration saying, please allow my citizens and hostile NGOs to sue me directly in an international court.
Your assumption is correct. As the source material notes, very few states have made the Article 34.6 declaration. Currently, only a small handful of nations maintain active declarations allowing direct individual access. Consequently, the vast majority of direct applications filed by individuals to the court are dismissed immediately for lack of jurisdiction because their home country hasn't signed that specific provision.
So, practically speaking, for the vast majority of citizens on the continent, the African Commission in Banjul remains the primary and often only battleground for individual human rights complaints.
That is currently the reality.
Before we close the book on the African system, The syllabus sources highlight one more treaty that we must unpack. It's described as one of the most vital additions to the African architecture, the Maputo Protocol.
The Protocol to the African Charter on Human and People's Rights on the Rights of Women in Africa, widely known as the Maputo Protocol, was adopted in Maputo, Mozambique in 2003. It entered into force remarkably quickly in 2005.
The sources describe the Maputo Protocol as an incredibly progressive instrument. In several specific legal areas, it goes significantly further than almost any other international treaty on women's rights, including the UNCEDAW Treaty.
It is a groundbreaking legal document that tackles the specific, localized realities of gender-based violence and discrimination on the continent. It explicitly prohibits all forms of violence against women, whether in private or public spheres. It is notable for being one of the first international treaties to explicitly forbid and condemn all forms of female genital mutilation, demanding states pass specific legislation to eradicate the practice.
But reading through the provisions where it truly breaks new ground internationally and where it caused significant debate is in Article 14 concerning health and reproductive rights.
Article 14 of the Maputo Protocol is a landmark in international human rights law. It explicitly guarantees the right to self-protection and to be protected against sexually transmitted infections, including HIV/AIDS. It guarantees the right to family planning education. And most significantly and controversially on the global stage, Article 14 explicitly guarantees the right to a medical abortion in specific cases. Sexual assault, rape, incest, and where the continued pregnancy endangers the mental and physical health of the mother or the life of the mother or the fetus.
For a regional treaty to explicitly enshrine the right to a medical abortion in those specific circumstances is a massive advancement in codified international legal protections for women.
It is. It perfectly demonstrates the core thesis of why regional systems exist. It shows how a regional system, operating with shared cultural understanding and tackling specific regional crises, like the devastating impact of the HIV/AIDS epidemic and high maternal mortality rates, can sometimes leapfrog the United Nations. Achieving that level of explicit consensus on sensitive reproductive rights would be nearly impossible at a global UN level, given the diverse religious and political views of 193 nations. But regionally, they built the necessary legal architecture.
We have toured the construction blueprints of three massive, intricate, continent-spanning legal systems. We've looked at the European appellate model, the American gatekeeper model, and the African holistic model. Now we need to ask the crucial question for you, our listener, who is synthesizing all of this for your Osmania University Unit 3 exam, or perhaps you're simply trying to understand how global justice actually functions. Let's connect all of these massive concepts back together. So what does this all mean?
When you lay the blueprints of these three systems side by side, the profound realization is that human rights are not a monolith. The Universal Declaration of Human Rights provides the core vocabulary: life, liberty, equality. But the grammar, the syntax, and the actual mechanics of justice change depending on the region's history.
Right. If you look at the globe, Europe's system, built around a powerful direct access court in Strasbourg with strict rules of admissibility and a 6-month filing window, reflects a post-WWII desire for absolute, court-driven legal accountability. They faced the collapse of domestic law into fascism, so they built an international appellate court to binary code human rights, broken or not broken. You exhaust domestic remedies, and then Strasbourg issues a binding judgment.
Conversely, the inter-American system reflects a hemisphere fighting to emerge from the shadow of military dictatorships, secret police, and systemic clandestine state violence. A strict appellate court requires a functioning domestic system to appeal from. If the domestic system is run by the military junta doing the disappearing, an appellate model fails. Therefore, the Americas needed a powerful commission to act as an aggressive investigator and a gatekeeper, utilizing the Actio Popularis to allow NGOs to speak for the disappeared when victims couldn't speak for themselves, and they equipped their court with provisional measures to act as an emergency brake on imminent harm.
And the African system reflects the monumental post-colonial struggle. It prioritizes the survival of the community alongside the individual. It introduces anti-colonial people's rights to self-determination and resource control. It blends civil, political, and economic rights into a single indivisible charter. And philosophically, it insists that an individual's rights are inextricably linked to their duties to their family, society, and state.
Understanding the architecture of these systems teaches us a vital lesson about global justice. The best way to protect human dignity isn't by forcing a single, rigid, global template onto every nation regardless of their context. It is by building localized mechanisms that intimately understand and are legally equipped to respond to the specific nightmares a region has historically faced.
Let's do a rapid-fire recap so you are fully armed for the exam. Unit 3, Regional Conventions.
What?
Europe. The anchor document is the European Convention on Human Rights, the ECHR. Key structural feature. Protocol 11 abolished the Commission, allowing direct individual access to the European Court of Human Rights in Strasbourg. Remember the strict admissibility rules. You must exhaust domestic remedies first, and remember the European Social Charter operates separately to progressively enforce economic rights.
2. The Americas. The anchor document is the American Convention on Human Rights, the ACHR. Key structural feature. The dual-track gatekeeper system. Individuals cannot bypass the Inter-American Commission in Washington, D.C. Third parties can file petitions on behalf of victims to combat forced disappearances. If a state accepts contentious jurisdiction, the Commission can escalate the case to the court in Costa Rica.
3. Africa. The anchor document is the African Charter on Human and People's Rights, the Banjul Charter. Key structural features. It combines all generations of rights into one document, legally codifies people's rights, and uniquely mandates individual duties. Understand how the Commission redefined the clawback clauses using international law, and remember the groundbreaking Maputo Protocol for women's reproductive rights.
An exceptionally thorough synthesis of the unit. You are well prepared for the mechanics of the exam. However, as an academic exercise, I want to leave you with a final theoretical puzzle to mull over, a question that builds on the architecture we've discussed today, but challenges the foundation itself.
Let's hear the final exam question.
We've spent this session examining how regional conventions tailor the enforcement of human rights to local cultures, traumas, and historical realities. But consider the long-term structural implications. As these regional systems grow stronger, more distinct, and more deeply embedded in their unique local philosophies, such as Africa's focus on duties or Europe's focus on strict individual litigation, do they ultimately strengthen the universal idea of human rights by making them culturally practical and legally enforceable? Or do they risk fragmenting the very concept of universal rights? If the legal definition of what constitutes a fundamental right and who is allowed to enforce it fundamentally changes depending on what continent you happen to be standing on, can we truly still call them universal?
That is the ultimate tension at the heart of international law. If the contractors all take the universal blueprint and build wildly different houses based on local weather, is it still the same architecture? That is a brilliant philosophical question to ponder as you review your notes. We want to thank you for joining us on this deep dive into the machinery of global justice. Keep questioning the structure, keep analyzing the sources, and go absolutely crush that Osmania University syllabus.